Now be seated. All right, is that because we didn't turn the light off last time, or have they got another question?
I don't believe it's the same light.
Okay. You ready? Okay, so we have a question from the jury. I am marking the written question. Number 1, it says, can we please be provided the definitions that were provided by the judge during the final instructions? I am assuming that they want the definitions for the charges specifically, but I need to ask that. So, counsel, what I'm going to do is I'm going to send them a question back in writing that says, do you mean the definitions for the specific charges? And if they say yes, then I'll bring them out and recharge them on that. If they say no, then we'll figure out what they do mean. Okay?
Yes, ma'am, no objection.
Mr. Dwayne?
There's no objection to it.
Okay. Take that and just tell them to flip the light when they have an answer for me. And we'll just sit right here because I'm 80% sure that's what they mean, but you know what they say about assuming, so I want to make sure I'm clear what they mean before we do that. If that is what they want, then I will I'll read just the charges and then remind them that they need to take that as part of the charge and consider all of the rest of the charge and reaching a verdict. There you go. Yes, the ones that explain malice, child cruelty, etc. Okay, so I'm going to recharge on malice murder, felony murder, aggravated assault, and the 2 cruelty charges. You can bring them in, please. Alright, I don't need the alternate. Alright, ladies and gentlemen, y'all have asked to be recharged on the specific charges, the definitions of each charge, so I'm going to do that now. I just will remind you that you're hearing the portion that is specific to these counts, but also you should consider those in light of the entire charge when you get back in there. Okay? Alright, malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder, or to be malice murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with a deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be malice murder. The state does not have to prove excuse me. The state does not have to prove motive to prove murder. Any evidence of motive that has been admitted for your use in determining the defendant, let me try again, y'all. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Count 2 charges felony murder with cruelty to children in the first degree as the underlying felony. Cruelty to children in the first degree is a felony for which I'll define for you now. Cruelty to children in the first degree, the state must prove that the defendant maliciously caused cruel physical pain to a child under the age of 18. In deciding whether the defendant acted maliciously, understand that malice is not ill will or hatred. Malice in this context means an intent to cause the pain without justification or excuse. Malice also means willfully doing an act while aware of a strong likelihood that the pain may result. Count 4 charges felony murder with aggravated assault as the underlying felony. Aggravated assault is a felony which I'll define for you now. For aggravated assault, the state must prove that the defendant assaulted another person with an offensive weapon. An offensive weapon is any object that is likely to cause or actually does cause death or serious bodily injury if used against someone. In deciding whether the unknown object is an offensive weapon, you may consider all of the following factors: nature and extent of any injury inflicted, the character or capabilities of the weapon, the manner in which it was used, any display of it to the jury, or any other circumstances of the case. Murder in the second degree. For murder in the second degree, the state must prove that the defendant caused the death of another person by committing cruelty to children in the second degree. The state does not have to show the defendant acted with malice to prove murder in the second degree. Let me define cruelty to children in the second degree for you now. For cruelty in the second degree, the state must prove that the defendant caused cruel physical pain to a child under the age of 18 through criminal negligence. Criminal negligence is a failure to act which shows a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured by this failure to act. All right. Take that with all of the other, I want to make sure I defined criminal negligence. I did. Okay. So take that in accordance with all of the law that I've given you and facts as you find them to be, and I'll let you resume your deliberations. Thank you, ladies and gentlemen. All right, my intention is if we do not hear from them again by about 6, I will inquire if they want to continue or go home for the night. If they go home for the night, we're going to have to resume Friday morning, which is not ideal, but I cannot be here tomorrow. So we knew we were going to have to work around that. So we'll just wait until we hear from them.
Is there a judge, Your Honor, that could potentially take the verdict tomorrow?
No, I don't think that's a good idea. Because if we get questions or we get issues, that becomes more complicated. And I'm not sure Judge Smith or Judge Adams are available. But we'll see. Let's see where we are then. All right, we'll stand in recess till we hear further from them. We have 2 more questions from the jury. First, what about if we believe the injury happened on Saturday, the 14th, but the indictment lists 15th to 17th? And then the jurors would like to ask if we can come back tomorrow. So first, on or about means if they think it happened on the 14th, I think that's sufficient. There is some language about that in the law that I want to be precise in how we charge them on that. And the other thing that's messy in trying to answer that question is the death occurred on the 17th. And so the elements of the crime, you see what so if it's felony murder and the aggravated assault, it's a little bit messy. So y'all take a minute and think about what you think is the appropriate response to that. I don't think there's any question that the law says and the indictment reads on or about or on or between whatever. So I don't think that is dispositive of the issue. And then, hang on, I'm going to let you both say what you want to say. And so when you are telling me what you think about it, number one, also, does it matter which charge we're talking about when we're talking about the date? Because does the homicide happen the day the injury is inflicted, the day of death, either or, depending on how it's indicted? And so those are the sorts of things we need to consider when we're talking about how we respond to that question.
May I?
Yes.
So I have used a charge in the past where the date is not a material element.
Right.
And they can be charged with that, and I can run back to my office and try to find a copy of that.
Well, that's what I was talking about when I said the on or about. I probably can pull it right here for you. But I think that's the start of the conversation.
May I respond?
You may. Go ahead, Mr.
If you know, please, normally an indictment will say that, but the indictments on all these counts say between the 15th day of November 2020 and the 17th day of November of 2020, the exact date of the offense being unknown to the grand jury. I say that because all of the counts say that. It doesn't say on or about.
Okay. But it does say on or between and the exact date being unknown. And I think that if you look in, so there are some cases, as he's saying, the date recited in the indictment is not a material element of the offense unless the indictment specifically provides to the contrary. So as long as the offense occurred within the statute of limitations. date is a material allegation of indictment if it is an essential element of the charged offense or if a defense such as alibi has been asserted. And that is not the case here. And let me look at the specifics of this. I'm looking at some cases, hang on. All right, if you look at Townsend v. State, which is 357 Georgia Appeals 111, this actually is working in reverse. So it's well settled that the date is not a material element, and as long as it is proved within the statute of limitations, in the absence of a specific allegation that is a material element or an alibi defense, then you're not stuck with the date. And in Townsend, this is actually a post-conviction argument about merger and whether these theft crimes merge. And the state is arguing that they do not because they were alleged to have happened on different dates. But they're all the same victim, the same stuff, and they do merge because the state failed to allege the date was a material allegation. So I think, whichever way you come at it, the answer is that the date is not an essential element of the crime charged as long as a crime has occurred within the statute of limitations.
And we will not concede that point.
Okay, then that's fine. And so, let me, I want to look at one other thing before I All right, and if y'all look at Reed v. State, which is a Supreme Court case from 294, Georgia, 877. That's March 28th of 2014. Where the date is not alleged to have been an essential element, the defendant did not assert an alibi, and this is a homicide case, and so and in that case it was May instead of March, not within 24 hours. And the Supreme Court says, even though it's been held that a definite date of an offense should be alleged in an indictment, the state is not restricted to proof of the date stated. It is sufficient if the evidence demonstrates that the offense was committed at any time within the statute of limitations, except where there's an alibi or it's alleged that it's an silly any variance except in the absence of an alibi or being made an essential element is of no consequence. So I think the correct response is that hold on a second, let me think out loud. I'm going to tell you exactly what I'm going to say and then let you both comment for the record as the law requires. All right, what I would like to respond to this question is, the state is not restricted to proof of the date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt the offense or offenses occurred within the statute of limitations.
Can you repeat it again, please?
The state is not restricted to proof of the date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt that the offense or offenses occurred within the statute of limitations.
I think that's okay.
Mr. Greer?
Of course, I don't have any legal cases to cite to the court, but I would object to that.
All right. Your objection's noted for the record. I'm going to give that, I'm going to write that exact wording down to respond to their question.
And I have no objection to them coming back another day.
Okay, and I'm just going to tell them the choices tonight or Friday morning at 9.
I would ask them essentially see if they'll return a verdict tonight, Judge, based on.
I'm going to let them choose if they want to stay tonight or they want to come back Friday. And I'll just tell them that they've been on our schedule, we're on theirs.
Yes, Your Honor.
But I need to not write and talk. state is not restricted to proof of date stated in the indictment. It is sufficient if the evidence proves beyond a reasonable doubt the offense or offenses occurred within the statute of limitations. And I also wrote, you may continue to deliberate tonight or come back Friday morning. The court will be unavailable tomorrow. Either is fine, just let us know. You may also take a break when needed. Mr. Davis, take that to them, please. No, I said the court is unavailable tomorrow. Let's wait a second and see if they're going to tell us what they want to do before we all disperse. And they've still got the light on, Bob, so. We won't know when they need us if they don't turn it on.
It's back on.
Okay, the note says, we have one juror who says she isn't open to discussion, who is combative to the room. What do we do here? She said she will not change her mind in a million years. Please advise. So, the issue for the court is a juror should never surrender an honest opinion. But a juror does have to participate in deliberations. So my suggestion at this point is that we Allen charge them, because that talks about you have to listen to each other. Let me pull that and look at the pattern. Because we have to be very careful with investigating which it is. That a juror has a belief based on the evidence that they're unwilling to surrender, which the system is set up for, or whether a juror is just refusing to deliberate.
Judge, I would argue to the court, I don't think we've got far enough yet. I think it's probably too early to do an Allen charge.
Okay, go ahead.
I would suggest that we come back Friday morning and give them some more time to deliberate, and then after a period of time that the court deems appropriate, if the stance is still that way, then do the Allen charge.
Well, I think it's not so much the first paragraph of the Allen charge, but the second part that says each juror should listen to the arguments of the other jurors with a disposition to be convinced by them. If the members of the jury differ in their view of the evidence, that difference of opinion should cause them all to scrutinize the evidence more closely, re-examine the grounds of their opinion. Your duty is to decide the issues that have been submitted to you. If you can, conscientiously do so. In conferring, you should lay aside pride of opinion. Bear in mind, a jury room is no place for taking up and maintaining in the spirit of controversy either side of a cause. You should bear in mind at all times that as jurors, you should not be advocates for either side. You should keep in mind the truth as it appears from the evidence, examined in light of the instruction of the court. I would encourage you to continue this case. I mean, because just sending them home is not going to change the dynamic. I don't know that the dynamic should change. I don't know what, because combative is one thing, never surrendering an opinion in a million years is a different one from a legal standpoint. And the court has to be very careful in invading the province of the jury. However, I'm talking myself around into what I think is the appropriate thing. It is late. Everybody's tired. I think I'm going to send them home, tell them to come on back Friday morning at 9, that, and I may, then we'll, I'm open to thoughts on whether I should address, if I need to address this at all, or just send them home today.
I'm in agreement to send them home and bring them back Friday morning.
Mr. Crew?
I would think so also.
All right, if that's what y'all think. Bring them in for me, Mr. Douglas.
Do you want the alternates then?
Yeah, because we may need them.
If I may make one comment, just when you say them home, the media coverage has been everywhere.
Yeah. I will remind
It's
you.
all over.
Yeah, I know.
All right, so you want the alternates to about?
Ladies and gentlemen, it's been a long day. We're going to stop here for tonight. Unfortunately, I have somewhere to be tomorrow that is not here, that I cannot get out of. So we're going to reconvene Friday morning at 9 o'clock. Now, you can go on any computer and watch this whole trial again. I need you to understand, you cannot do that. Don't look at MAZ, don't look at Court TV, don't look at Fox, don't look at WGXA, none of them, okay? That is improper, and it will affect the ability of this court to finish this case. Don't talk about the case with anybody over the weekend or overnight. Just try to put it in a box until Friday morning, okay? Don't do any independent research. Don't go looking stuff up. All of that is improper, okay? So you're just going to shelve it for tonight. I will see you back here Friday morning about, let's aim for y'all coming in at 8:45. If all 12 of you are in the room, you can start deliberating. As you're coming in the morning, if there are 5 of you and that's all, you cannot talk about the case until all 12 of you are present. Okay? All right. Leave your notepads in your chairs or in the jury room on your way out. And I will see you back here at 8:45 Friday morning. Okay? Thank you, ladies and gentlemen.
Okay, Don.
For the record, I believe that is Shane Howard, who has handed me another. She maintains she's being harassed by the foreperson about her vote. So I'm assuming, so we're gonna send everybody home, let everybody cool off, and then, y'all be prepared to, discuss what is the appropriate remedy on Thursday and what, if any, investigation the court can properly engage in.
Judge, for that reason, I would want to make sure that the alternates are here on Friday.
Yeah, they will be. I've instructed them to come back with the rest. Anything else for the record?
Not from the state.
Nothing from us, Your Honor.
All right. Friday morning, y'all. We'll stand in recess.
Thank you, Your Honor.